All right, hi everybody. Welcome back. Attorney Steve Vondran. We are talking in this video about waiver of the service of summons. Happy Columbus Day. Hope you guys are all doing well. This is general legal information only and not legal advice. But we're talking about lawsuits, federal court lawsuits. This is a federal court form, as you can see up here. U.S. courts. When you see U.S. courts, that means federal, okay? So there's the state court system, there's the federal court system. But in every case, it doesn't matter if you're in state or you're in federal, you have a certain amount of time to respond to a complaint. For example, in a California court, you have 30 days to respond. Somebody sues you, you got 30 days to respond. Federal court, 21 days. It's a little bit shorter. You got to act a little bit faster, okay? Check your states. This is general legal information only, not legal advice. Every state has its own rules. But in general, whenever you sue somebody as a plaintiff, you have to serve the summons and complaint. That means both a complaint, the complaint that you filed, which has all your allegations, and the summons. The summons is basically just the court order. It's the court order that says you must respond. If you don't respond, we're going to give you a default and we could enter a judgment against you. So the summons is the court command that you must appear and answer or respond or risk waiving your rights, okay? So in every case, the plaintiff needs to serve the summons and the complaint. Now, I'm going to do another video about service of summons and complaint, service of process as we call it. And so bookmark it. You want to bookmark this video. Yeah, I'm going to do a great video. It's going to tell you all the ins and outs of how to serve the defendant, how to get them served so that you can go get a judgment, okay? I'm not going to talk about that here. Just note for this video, the question is, will you accept waiver of the service of summons? So this happens a lot of times amongst and between attorneys where somebody gets sued. Our client will call the office and they'll say, hey, I got sued. Here's the summons and complaint. I got sued. And I'll ask my clients, I'll say, well, did they actually serve it on you? No, somebody dropped it in the front yard. Okay, well, that's not really the best way to serve somebody, but some attorneys will do that just to try to get the ball rolling. And then I'll tell the attorney, I'll say, hey, you know, you like dumped it, you dumped it on his front door, or you put it, the dog ate it or something. And it's like they were never actually served. When were they served is a question I ask all the time. And if they say, I don't know, or, you know, we're not quite sure, they'll usually say, will you accept a waiver or service of the summons? That's what this form is, U.S. Federal Court. 21 days to answer in federal court. That's the rule. You got 21 days to answer or respond. And now there's, as you can see here, serve an answer, which usually if you're going to file an answer, you will file an answer and affirmative defenses. You say raise your defenses, or a motion under Rule 12. Now, these are your motions to dismiss in federal court. I have a video on that, Attorney Steve, motion to dismiss. Go check it out if you want to know more about that. Things like lack of jurisdiction, failure to state a cause of action, failure to state or should I say, claim upon which relief can be granted, okay? So some people will get sticklers with you on that. But if you accept this, which I like to do, and I like to cooperate with other attorneys, and there is good reason to cooperate. One is that you will get 60 days to answer instead of the 21, so you'll get an extra 39 days to answer or file your Rule 12b motion. So that's nice. It gives you some breathing room. The plaintiff can relax. They know they got you served. The defendant can talk about it. They have plenty of time to respond. So I like the waiver of the service of summons. As it says here, even though you accept the waiver of summons, you say, that's fine. I'm served, fine. You will keep all defenses or objections to the lawsuit. So it's not, you're not waiving all your rights. You're not waiving all your defenses. You're just saying, look, I'm going to cooperate. I'm going to agree to accept the complaint, service of the summons from the court, and I'm going to get 60 days to answer or file a motion under 12b. So it's pretty cool. Like you can see here, it's very simple. You put in your district court, it's fillable, put your plaintiff, your defendant, your case number, to the plaintiff, so forth and so on. So it's very simple. I like this. It's something for you to become familiar with. As you can see here, and for attorneys, there's a duty to avoid unnecessary expenses of serving the summons. So some people like to, I think some newer attorneys, younger attorneys right out of law school, they like to fight. Never served. They were never served. But I mean, come on, they're going to get you served at some point in most cases. So it's good. It gives you a benefit. You accept the service of summons. Boom, there it is. You get extra time to answer or file a motion. Okay? Attorney Steve, general legal information only, not legal advice. You guys have a great day. I got some more great videos coming. I'm going to be getting back to the whiteboard. I've been on a semi work sabbatical. So the whiteboard is coming back. I know you guys love it. I just had my 7th video reach 100,000 or more hits. So please subscribe. We love having you. We love your comments. Please leave your comments. And don't forget to give me a little like now and then. Hit the like button. It's not going to kill you, okay? Anyway, have a great day. This is Waiver of the Service of Summons.